Hello everyone, welcome. Let's see if everything's working here. I am Leonard French, your favorite copyright attorney, here to do a follow-up video. We don't do too many follow-up videos this, oh hey, Richard Hoeg is here, Ross is here. Ross, I forget your last name, even though I just saw it on the credits of your video that I was going through again. So, yeah, so what's today gonna be? A lot of people are asking. Am I going to rip apart Ross's arguments? Sort of, but I'm going to be kind about it. Richard Hoeg from Hoeg Law in Michigan. Oh, hey, Blackleaf is here. Welcome, good morning, afternoon. Good afternoon, Blackleaf. Also, Kaylee is here to talk about the EU perspective when we get there.
Yes,
thank you.
And it's Ross Scott, by the way.
Ross Scott, thank you. I appreciate that. So, Ross Scott is here in the chat. It looks like Richard Hoeg is here in the chat. We'll look for see who else of note might be here. You're all worthy of note, but of course, if I noted all of you, we'd be here for the whole stream. So, let's give the another minute here for the introduction music to play through and everybody to filter in. It looks like there are 217 of you currently watching. If you've already done the deep dive on this yourself, I'm probably not going to be revealing anything new. We're just going to go over everything in more detail. The comments on my previous video seem to indicate more of a disappointment that we didn't do the deep dive at first. And so I will apologize for not doing the deep dive. Even I had the thought as I was publishing the video, like, this is a bit short, but it'll be okay. No, it's a big problem. It's a big issue. And let me be clear right off the bat here. Ross and the overall concept and feel and message of the Accursed Farms video is not wrong. Let's let the music finish. This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. So, thank you for joining me. I am Leonard French, your favorite copyright attorney, and we are here today with Blackleaf and Ms. Kaylee to talk about the Accursed Farms, Ross Scott, Games as a Service is Fraud video or problem. And yesterday I released a video that we had made out of a live stream, as we typically do on this show, on this channel. We hold a live stream Sunday mornings at 10 a.m. on twitch.tv/lawfulmasses. And we typically make videos out of that. So this was a video that was just a short discussion of Ross's video, which was then published to Lawful Masses, which we've been sort of, that's been our format, which, yes, some of you have accused me of that being sort of low-hanging fruit or easier. We're working on figuring out our production scheme. I want to do more written, edited videos, but they also take a lot of time to do properly, and I have high standards and tend to make mountains out of molehills. So, but you're not here for all that. You're here to talk about games as a service. So I wasn't sure how we want to do this. Ross's video is an hour and 15 minutes. I did go through every single minute of it. We downloaded the transcript and went over that, as well as I watched the actual video all the way through. Like, I literally heard every word on the video to make sure that I would touch on every single topic. And if I go through and watch Ross's video with you now, which he's in the chat, I could probably get his permission to do that. I mean, even if it is a fair use, we could still have permission for that. But it's still going to take 75 minutes of his video plus our analysis. Instead, we've sort of written a minute by minute or play by play rebuttal or answer, or at least I have. How about Kurt? What have you done? Anything like that, or how have you prepared for this?
I have watched his video in full, and so I'm prepared to comment on that.
Okay, so what I thought we would just do is start going through kind of a minute by minute of the concepts of the video instead of watching the video itself. I do have some visual aids. They're pretty much the same visual aids that Ross and attorney Richard Hoeg used. Richard had posted on Twitter a bunch of the links that and just made it much easier for me to find the Linus Tech Tips post and some of the other things that were referenced. And then I have a few exhibits of my own as well. So I thought we should just go through that. Are there any preliminary problems that I can solve before we get started? Can everybody hear Brandon? It's not Brandon. Brandon's in the chat. Can everybody hear Kurt and Ms. Kaylee and me just fine? And does anyone demand that we watch? Not that I'm going to do it anyway, but does anyone really, really, really want to see that we watch Ross's whole video again here on this stream? I don't think so. I think this is going to be the best way to do this.
I mean, even Ross now says just skip to the parts that you think that matter. So I think that is now a permission that we don't have to watch an hour-long video. Now we can just pick the parts we disagree with or agree with.
And let me make one giant confession here. For those of you, because this isn't the way I looked at it from my perspective, but obviously some viewers did. For those of you who called me out on not watching Ross's entire video before we talked about it on our Sunday show and published our Tuesday video on it, no, you're correct. I did not watch the entire video. We skimmed through it, and here's my arrogance. Let me defend my arrogance just a little bit real quick. I've discussed this issue before at length. We've discussed it here privately on the channel, but I'm not going to say that really counts much. But where you might not realize that we've discussed this is in the law. Lawyers are required to do continuing education called continuing legal education, or CLEs. Of course, the phone's going to ring the moment. There we go. Actually, let me put that on mute. I've gone to CLEs, continuing legal education courses, where this has been the topic. The games as a service, or at least software as a service, has been the topic. So I guess that's a good segue to lead into. This whole thing, in my opinion, stems from the software as a service problem, which sort of preceded it. It was a paradigm shift in software development over, well, the last 2 decades maybe. Publishers used to sell copies of finished software on a shelf, and the internet has changed distribution models forever. As long as we have a reliable internet, publishers will continue to seek to build a subscription or service model on top of the products that they previously would have sold as a boxed copy on a shelf. Even today, a lot of times you go and buy a boxed copy of something, and all you're doing is buying a link or a serial number or something that takes you to a page or site or app or something that then authorizes your license, and you often have to agree to that license at that time. Let's get into all that a little bit as we go. How do we want to do this, Blackleaf and Kaylee? I don't have like a raise your hand system or anything like that, so just like break in. I'm totally capable of talking over all of you, so please.
Well, I'll say a couple notes in preliminary. First of all, I thought his video was very good. In general, covered the topic fairly well, covered the issues. I thought it was a fairly comprehensive, good video. And the other thing that sort of struck me as weird about the comments to your video, Leonard, was it seemed like people were massively overreading what you were trying to say in the first place. Because you were trying to get some fairly nuanced points about this fraud issue, and people were seeming to read it as like you were trying to like slam him completely. So
I didn't think that came off that way. My major disagreement is that the games as a service model automatically by itself, without more, is not fraud.
No, that's what I understood you to say.
That's it. That was really all I was trying to say, was that it's everything else. It could be a consumer protection act. It could be a violation of a Fair Business Practices Act. It could be a violation of contract. Contract's the big one. And I think the major take or major misconception I was taking from Ross's video was the goods versus service distinction, and how they can sort of be in between, and how copyright and licenses works differently than traditional tangible goods or pure service organizations or pure service offerings. And a few others that I'm sure we'll get to in my notes here, rather than just talk all at the beginning and then have to go through this again. So let's see. So in my opinion, software as a service, yes, it definitely could have originated earlier, as in 1983 and all that. The concept isn't new, that services can be more profitable than selling a single individual good. Really, any good businessman or business person has at some point realized that selling one product doesn't sustain you over time. You either have to continue to sell new products or you put yourself out of business. If everybody needs a widget and your widget lasts forever and you clear the market on widgets, which means you sold to everybody who wants a widget, you've just put yourself out of business. Unless the widget breaks and they need you to repair it, which is the Apple right to repair issue, or unless the widget just wears out and needs to be updated, or in this case software needs to be updated to run with new versions of Windows or Mac or Linux or whatever, to overcome security flaws or to add new content. Now we're getting into grayer and grayer areas, right? So the thought that a service model provides longer sustainable profits is going to come into this a lot. Let's see, Ross's checklist. I disagree a bit that we can cross all those things off the checklist and say that those are not games as a service. Let me see if I can get a copy of that checklist up on the screen here from his video. I'm very close here. There we go, I've got it. So this is the checklist where he has crossed off the things that he believes are not games as a service. And this is sort of why a partial place where we disagree. I think that having online only certainly could be part of a games as a service thing, but I also agree that adding these other elements is something that the industry is doing to keep subscriptions or keep either payments or... I gotta close things on my computer that keep popping up because I'm doing this in the middle of the workday. Adding matchmaking or stat tracking or whatever is a service that someone has to provide. If the game developer is providing it as part of their game, then shutting that off is something that they... Here's the other version. When I say that they're allowed to do it, I mean that the law stops short of calling it fraud. That's what I'm going to mean when I say that for this stream. So they're allowed to breach their contract. They're allowed to violate consumer protection laws and then have to pay the consequences for that. And it never rises to the level of criminal fraud. Only something that we would have to classify as a criminally intentional deception with an intent to steal your money, basically, to deceive you into providing your money, is not the same thing as we made a license agreement and you didn't like the product that was delivered under the license agreement. If that was the case, then every time a manufacturer screwed up on an order, it would be fraud. And it's not. Even I, who love to claim bait and switch when Amazon switches something on me, I'm probably not going to try and sue Amazon for fraud. I don't think they intentionally did it with the level of criminal intent necessary. Thoughts, Blackleaf?
No, I agree with everything you're saying. Fraud requires a much more specific intent at the start, where you're trying to purposefully deceive in ways that are not really present in what we're talking about.
Yeah, and Richard Hoeg also makes a good point that breach of contract, it's not breach of contract when you operate within the contract just in a way that the opposing party doesn't like. So if the contract, your license agreement with the game company or game distributor, Steam or Uplay or Ubisoft or Activision or whatever, if your license agreement allows them to terminate and they terminated within that license agreement, or they altered the game or they patched the game within that license agreement, that's not a breach of contract, and it's probably not a violation of any law either, unless, well, there's a big unless here. We're not necessarily covering cases where something has been screwed up. If the license agreement does not cover an action, then it could be a violation of the contract or a violation of various laws that fill in, like the Uniform Commercial Code, that fill in provisions that are missing from contracts. It could be a violation of consumer protection law because there was not something in the license that covered a disclosure or a termination event or something, and then the consumer feels violated, and it could be a deceptive business practice or something, but it's probably not fraud. That's mostly what we're getting at here. It's not fraud. It's everything else though. So this is sort of it's all but fraud kind of video. Ross and I agree on everything except that this reaches the legal definition of fraud. So what we're really doing is having a big powwow here about how we can understand and attack the games as a service problem, rather than whether or not it's actual fraud. So let's continue here. Minute 7, Ross's definition of games as a service is limited to a very narrow outcome of where they can shut down your game. And that's true that this problem occurs in part because they can shut down your game, but when you go back to the license agreement, you've agreed that they can terminate the license at any time, and that the license, governs the playing of the game or the operation of the game, and that upon termination you must either destroy your copy or cease playing the game or something like that. One of the misconceptions is about, well, what happens because you own a copy of the game? Well, yeah, here's where it gets muddy. You own the copy. And if the copy was all that was necessary, the physical, tangible copy, including the digital file, which I'm including as a tangible digital copy, you own the right to that file, you own the right to that cartridge, or you own the right to that disc. That's the first sale doctrine, and that's codified in U.S. law and backed up by the courts, and there's also EU directives on it. I think Kaylee can speak to that if we want to do that now, or we can talk in a moment. But you own... Go ahead.
Sorry, I touched on the response. So
Go ahead.
I'm mainly gonna leave most of it, but indeed, like a lot of it is indeed just that you only have access to the game. Like all the other properties are not included to it. So yes, you have digital content itself, but that's where it ends. So they are able to cancel it at some point, and I will elaborate more on that later with the new EU directives. So yes, it's a good, but no, you don't have access to the properties or a title to get it forever.
So one of the first misconceptions to clear up is what's what we call the first sale doctrine. You own your copy, but that doesn't mean that you own anything more than your property interest in the copy, that one copy, and whatever your license agreement is with the seller. Many, many times today, and here's where I'll bring up one of the exhibits that Attorney Hoeg used, was the back of the Division 2, I guess this is the original Division, like box copy. And down here, if you look very carefully, it says online multiplayer requires a PlayStation Plus membership, software subject to license and limited warranty, terms at ubi.com. They may retire the online portion of this game at any time. So yes, that is tremendously unfair, right? Like that, I know I want to be able to play my game forever. I paid my $60, but if you know ahead of time what that they can retire the game, and you can look into the past and say, well, they've retired games, a couple years after they've released them. There's really no reason to feel deceived in any way, let alone that the court is going to read that provision very black and white. And if you later come and say, well, I expected them to have the game up for 5 years and they only had it up for 3, the court's not going to look at you as having some sort of legal remedy. The black and white text has the black and white text of the notice here, even just on the back of the boxed copy, says that they can do that. Now, if it doesn't say that and they shut it down, yeah, you might have a legal claim there, but your legal claim is going to be for breach of contract or for unfair business practices or for something else with an I keep saying anti-consumer law, a consumer protection law. It's a consumer protection law to prevent anti-consumer practices, not an anti-consumer law. Although those exist too, right? Like maybe car dealerships. Is that an anti-consumer law? So then you own this offline copy, and if you can make that work, you're allowed to continue to make that work. There's actually an exception built into U.S. copyright law. The Register of Copyrights formerly was the Librarian of Congress. Now it's the Register of Copyrights and the Librarian of Congress make exceptions to U.S. copyright law in the form of DMCA exceptions. And number 8 here, which I unfortunately broke my highlight there, is literally a exception allowing video games that require server communication to be preserved for individual play or preservation. And so this doesn't necessarily mean that the developer has to provide an end-of-life plan. The developer, I mean, they have their own internal plan in that sense. They make a license agreement with you and then they terminate the server or whatever. That's their end-of-life plan. They don't have to make a more comprehensive end-of-life plan, but they can't pursue you for copyright infringement if you figure out how to bypass their DRM to allow the game to be played even when they take down the server. But then we have this other overlapping problem: the copyright ownership of the developer and your desire to play the server part of the game. That I know some games will provide you with server software and you can set up your own server, but let's use the Division or Division 2, for example. They maintain the open world, they maintain the servers, and when they shut down the servers, you're not going to be able to play the Division 2 anymore. Your client is just that, it's just an end client, and unless someone rewrites or recreates their own server that is somehow compatible with the client software that you have. So this sounds like a giant problem. It's unfair to you because you paid for the game and you just want to be able to continue to play the game even after Ubisoft shuts off the servers. Well, Ubisoft has to take care of that in their license agreement with you and has to set expectations properly. And you have every right to want to know from your contract what is going to happen at the end. But the contract's going to say something like we just saw: we can shut it off at any time. And so ultimately your remedy is either buy the game knowing that it's subject to those limitations, or don't buy the game. Is there something you can do with consumer protection laws or something that say that they have to maintain the server afterwards? No, because then you get into the purpose of copyright. What is copyright protection for? It's to protect the value of the creative work for a long enough period of time to incentivize the creation of significant works of creativity, art, science, etc. And then only after a period of time, in this case, life of the author plus 70 years, which is a long time, then the copyright expires and anybody can go use works whose copyright has expired. For example, Homer's Odyssey was one that was brought up. Well, guess what? You can go use Homer's Odyssey to make a new work out of, and you can go see Joel and Ethan Coen's "Oh Brother, Where Art Thou," which is a retelling of Homer's Odyssey and was a blockbuster movie at the time. In fact, it's one of the I love to watch that movie once in a while because everybody's just so funny in it, and George Clooney is a great actor, and nobody even had to write the original story. They just had to adapt Homer's Odyssey to the screenplay that they wanted to make. Other thoughts while I'm pausing for a moment? Everyone is silent. So my one of my major disagreements, minute 8, was that the goods versus service distinction. It's not a situation where you can really put the whole situation into the box of goods or services. It's both. It spans both legal treatments, and so the copy will be treated as a good, and I believe Ross cited a trademark ruling or trademark categorization of goods and software and stuff as a good, and that's fine, but trademark is governing the source of goods and services, and trademark only has goods and services. Trademark does not have a separate category for things that aren't goods and services. It's either a good or a service, but that doesn't mean that other areas of law recognize that software is just a good or just a service. It's going to be different. Contract law is going to look at it a lot differently than trademark law. Trademark law won't apply to the contract much at all, and vice versa. Contract law won't apply much to the trademark. If the trademark is not registered or improperly, it really has no bearing on whether the good is fraudulent or not, or whether it is properly copyrighted or not. I'm sort of rambling. Let's continue. All right, so we get through minute 10. This is the Linus Tech Tips post. Let's bring that up and see what we can see about this. There was this post on Linus Tech Tips, July 30th, 2018, and I'm going to go through the whole thing here and refute it so there can be no question. Some of the bottom part of this post is a paste. I managed a message I sent to Steam support. Okay. To be clear, Steam discussion moderator's assertion is wrong. Top courts covering a sizable amount of the world's population have ruled that they're wrong. Okay. We'll get to that, I guess. Software licensing and purchasing and owning software 101. A license is a right to use a property or intellectual property that belongs to someone else. When you read this software is licensed, not sold, whether it's for Windows 10 or a gamer application, the software refers to the intellectual property and not the copy of the intellectual property that you've purchased. I think it refers to both, actually. Software licenses and the instance of software's intellectual property that they represent are indeed and obviously sold. Yeah, this is just the distinction of whether it's a license or not, and that's what that means. And courts have definitely upheld your right to contract for your video game instead of buying a what would you buy anyway? Like here's like follow it out to its legal conclusion or to its logical conclusion. If we weren't talking about a license, what are we talking about? This is not the same thing as a book where you want to get all the words in the book, right? You don't get the code in its source format. You get the code in its object format. So we're already far away from the normal buying of a copy. You sort of have to buy more than just that copy. If you don't have a license, then really what's going to apply is just consumer protection law, and there'll be some warranties and things that will apply that don't normally apply because they get waived. So there has to be some kind of license. There has to be some kind of agreement. Otherwise, you're sort of doing the same thing, but you're doing the same thing with some default provisions. How this works is there are various, not just consumer laws, but also commercial laws about how goods are transacted, about how various transactions. I'm talking about the Uniform Commercial Code, the Magnuson-Moss Warranty Act, and I'm not a contract attorney, and I'm not a UCC attorney, although I did take that course in law school. These will fill in or override ineffective provisions in the contract. I mean that specifically. A provision in a contract that is either not there and is ineffective because it's simply not there, or falls short of using effective language, using language that is effective under the law. Like, let's say that company A orders widgets from company B and they forget to put the terms of delivery in the contract. Well, UCC will probably fill in something about a reasonableness within the industry. So you could expect that if you ordered a widget from company B it would take the reasonable amount of the automatic fill-in term in the contract that you forgot would end up being a reasonable amount of time for that industry. If it normally takes 6 months to deliver a Boeing 737 MAX, then if you forgot to ask for it within 6 months or something, then the terms would be around about 6 months. Although hard to argue when you don't have the provision, but in case there are things like that that are forgotten, the UCC fills them in, and commercial companies, not necessarily individual citizens, but people who deal with each other in commercial contracts and things, know that this is going to happen if we forget something. What happens when two companies have contracts for their services and they have to exchange these contracts and they don't agree? What happens to the provisions that don't agree? Well, this is all governed by various laws, like the Uniform Commercial Code. Back to this. All the mass-produced items you've bought, your clothing, your vehicles, your TV, your computer hardware, are licensed instances of... sort of. I'm not sure that you own a license to anything with regard to your vehicle, your clothing, your TV, even the computer hardware isn't licensed. You own a copy. You own, and it might be subject to a warranty or to consumer protection laws, but you don't own any sort of intellectual property or even touch the intellectual property for those goods or services. But yes, the author is not wrong that intellectual property rights are implicated on the ownership side, that you don't own the right to the vehicle or TV's design or computer hardware or etc. When you purchase, you aren't purchasing the intellectual property, correct? But you are purchasing a one-off copy, correct? In law, a good is, by definition, an item that undergoes a transfer of ownership at its point of sale from seller to buyer, granting the buyer full property rights. Where are they getting this from? Key differences between goods and services. How about we try Black's Law Dictionary? And this isn't even going to be an authoritative answer. This is going to be a dictionary answer, which is just one source, one source of information. Definition of goods. In contracts, so they're already limiting it to in contract law. The term goods is not so wide as chattels, for it applies to inanimate objects, and it does not include animals or chattels real, which is real estate, as in like land property. Okay, so that's the definition according to Black's Law definition. In contracts, the term goods is not so wide as chattels. Great. It does not. Black's Law dictionary doesn't give us much help there, does it? Well, fail. So that's not going to help us much. But yeah,
that's good. Yeah, like chattels is basically anything that's not real estate. So goods would have to be some sub-portion of that. That's very helpful. Thanks.
Maybe we'll try consumer goods. Let's see what it says here. A category of mass market items divided by durable goods, non-durable goods, and soft goods. So there are even various definitions of goods within the goods definitions. And that's complicated, and that's definitely something to note, and the reason why this problem is occurring in the first place. Yeah, we're going back to the Linus Tech Tips post.
If I may be allowed a slight diversion here.
Go ahead.
This whole
Divert all you
discussion
want.
between good and service reminds me a lot of the distinction between an employee and a contractor in employment law, because companies like Uber, for example, are very desperate to keep their workers as contractors rather than employees. And what the company wants them to be and what they say they are is not necessarily true. So Uber may want them to be contractors, may say they're contractors. Where they are contractors is a whole other discussion. And so going back to the topic at hand, whether something is a good or a service or a license, someone may represent it as such a thing. It may be sold as a certain thing. It may be labeled a certain thing. Whether is that thing is where, lawyers get paid.
Okay, so then back to this. There are perpetual software licenses and subscription software licenses. I'm not sure that I agree with that definition. Perpetual software license is just a license that doesn't have a set termination date. They can still have termination conditions or such, but it doesn't really change the legal effect of having a end user license agreement. A perpetual license is non-exhaustive, meaning that the right it grants is eternal, forever lasting, never expires. It just means that it's not set in the contract that it expires at a certain time. A subscription license is duration limited, or I think it's also called a non-perpetual license. All the most common software, including games, are perpetual licenses. I wouldn't doubt that they're perpetual licenses, but there are termination conditions in them if you read them. Perpetual license is a product, okay, and whenever a perpetual license is sold, it undergoes transfer of ownership upon point of sale. Well, the license doesn't. You don't own the license. I mean, it's. Yeah, that's interesting. I don't know that the license transfers ownership. I think it's a license. The ownership is referred to as a license. So to say a license is a transfer of ownership is a bit of a misnomer. Blackleaf, am I off here?
Nope, you basically got it.
Whoever owns a perpetual license owns the instance of software, and it grants a right to use the intellectual property right, but that would be under the terms of the license. After the transfer of ownership of a perpetual license software, the seller of the license no longer holds any. Not true. Not true. Absolutely not true. We have the Verner V Autodesk case and others that say that you can license software and have it not be a first sale issue. If it's properly done, which it has to be properly done. In other words, if you forget to disclaim or waive the first sale provisions, or you forget to call it a sufficient enough license, or the terms of the whole, or the conditions of sale and all that don't reach the level where you've licensed it, then yeah, it's a first sale issue, and the copy can be sold or transferred away. But we have Verner V Autodesk, which went up to the Ninth Circuit, and it was denied certiorari in 2011. So that's a tough one to explain, but let's try it. A case goes to the Ninth Circuit, which is only 9 of 13 circuits, and the case says one thing. It says this first sale doesn't apply when the license disclaims that you own the copy of the product. So in Verner's case, Verner had bought older copies of AutoCAD, I believe. A business was closing down or whatever, but the business never had the right to transfer because the business had signed or agreed to a license agreement that said they only owned a non-transferable right, and when they went out of business or otherwise stopped using of the product, they had to destroy the copy or otherwise not transfer it away. And instead they did transfer it away, and then Verner ended up putting them on eBay. And Autodesk intervened, got the things taken down off eBay, and then Verner had to sue in order to keep eBay at bay. And the case went all the way up to the Ninth Circuit, and the Ninth Circuit said, well, actually, the district court, the original, or the court of original jurisdiction, said that there was a right of first sale. And that meant that the AutoCAD copies could be resold or retransferred using their original serial numbers or something like that, and the original copy would have to be destroyed and all that. And then the Ninth Circuit said, no, we disagree. That was a license situation, and because it was a proper license and the license terms did not allow its transfer, then Verner could never legally own the thing to begin with, and it was okay for Autodesk to stop his sale of the copies. Well, this went to the Supreme Court then, and the Supreme Court said, nah, we don't want to hear about it. What does that mean? That's a problem. Because if the Supreme Court had taken the case and then said, yes, we agree, this is the law of the land, that would be very clear. But they didn't. They denied certiorari, which is a way of them saying that we don't feel anything needs to be changed here, but it's also not automatically legally precedential and binding on the other 12 circuits. So the Ninth Circuit said it, and we can sort of assume that that's the law in the rest of the 12 circuits and the rest of the country, not necessarily the rest of the world, but we wouldn't really know for sure until we got a final ruling from the Supreme Court on it. But it's persuasive, it's extremely persuasive law to say that Verner V Autodesk, applies outside of the Ninth Circuit. And it is precedential law to say it applies in the Ninth Circuit. And the Ninth Circuit's California anyway, which is where a lot of the IT and tech for the US is done. So then back to this thing. EULAs are not laws, but subject to laws. That's true. Corporations do not possess lawmaking powers. Arguable. Lobbying. Many EULAs are not written by legal experts. I deny that. Any good EULA with a fairly good sized corporation is going to have been written by a lawyer. This governs your relationship with your consumers, with your customers. If you mess this up, you could end up losing your whole business. There've literally been misplaced commas that have cost billions of dollars because it said something like excludes X, Y, comma, and Z plus B. And it should have said X, comma, Y, comma, Z, comma, plus B. And then because of that missed comma, it meant a whole bunch of employees or contractors were then lumped in. I think it was the taxi union or something was lumped in and then therefore had to be paid benefits or something, and it was billions of dollars. And that was one example. EULAs are also used as a tool of manipulation to psychologically ward off potential challenges and provoke the type of consumer behavior a publisher wishes there to be. Well, sort of. I don't agree that it's anything illegal, but yeah, making a complicated end-user license agreement means that consumers aren't going to want to read it. Making its terms very, very favorable to the company means that the company is going to make maximum profit. Protecting the company from any consumer rights or consumer complaints tends to be the best interest of the company. Here, there's an example where these things butt up against one another. It would be in the best interests of these companies if they said, you're not allowed to review our game unless you're leaving a positive review. Wouldn't that be in the best interest of your company? Absolutely. Why don't you just put that in the Division 2 language that says, you're not allowed to write anything bad about our game? Well, that triggers an anti-consumer. I did it again. That triggers a consumer protection law or a deceptive business practice law or an unfair competition law. Is probably still not fraud, though. Just because you put that in there and you knowingly, whatever, you're not deceiving someone into giving you their money, in some criminally deceptive way. Ownership over a thing is what establishes one's decision-making authority over a thing. Well, again, you have to distinguish between the what part you own. Yes, you have absolute decision-making authority over the part that you own. The part that you don't, you don't. So you don't have authority over the server software, but you do over the particular copy of the client that you own. You can choose which drive to install it onto. You can choose to make a backup copy. But that doesn't extend beyond that. You can't choose to override the terms and your relationship with the publisher. Anything sold via a perpetual license is a product, and that becomes the sole possession of whoever purchases it. Again, only that copy. And then here's the European Union Court of Justice ruling that I wanted to go over. This is the same thing that we're talking about with the U.S. This is the right of first sale. They cite this here, the first sale doctrine, which is the way the U.S. refers to it. And down here, the Court of Justice of the European Union found that a copyright owner exhausts the right of distribution to a copy of a computer program once he sells or authorizes the sale of the copy. And this means that the European court agrees that there is ownership in the copy. And again, it's limited to the copy. Let's go back to the Linus Tech Tips thing. There was a 2016 Australian case. I believe I bring this one up as well. It was over whether or not the Australia's consumer protection law applied to Valve's sales of games on Steam, and it did. And they ruled that Valve did, in fact, reach Australia's consumer protection law when they sold goods. In this case, that's sort of what made this make the list here, is that Valve was selling goods, as the games were considered goods, under Australia's consumer protection law. And that's fine. That doesn't actually change our games as a service discussion very much at all, because what the Australia High Court was saying was that the consumer protection law recognizes the sale as a sale of goods, and therefore it deserves protection that sales of goods would receive under Australian law. It doesn't change the nature of the relationship between goods and services within the thing. It doesn't change the fact that it's a license, but it does mean that that license has to comply with Australia's consumer protection law. That's really all that means. And let's see here. I think they even have a quote. Each of Valve's challenges to the application of the Australian consumer law fails. The conflict of laws provision in the Australian consumer law do not carve out an exception for conduct by foreign corporations. So the conflict of laws is one of the hardest topics in law school. And it's a very complicated way to evaluate which law takes precedent over which other law. And the short version here is that contract law is overridden by consumer protection law in this case. And just because Valve had some kind of disclaimer or waiver in their license agreement with Australian customers didn't mean that they could work around Australia's consumer protection law by waiving it in that contract. So that's what that means. The conflict of laws provisions don't carve out an exception for Valve to waive consumer protection law. And the software is still considered goods and not considered an exception to the consumer protection law as not goods or something like that. That's what that is. In Canada, the government declared as goods all computer programs and software, regardless of recording media or means of dissemination. I'm not sure what this is. Let's take a look here. I didn't follow this link out. Oh, this is Trademark. So yeah, Trademark only has goods and services. So, and Trademark is usually called a trademark for goods and a service mark for services. There's little distinction under the law anymore now. It's really just these classifications of things. This doesn't affect other laws. Like, this doesn't change contract law or the law of the licenses, which is contract law. Nor does this override consumer protection law or anything. About software ownership in the USA. A specific matter of software ownership has never gone to the U.S. Supreme Court, and it's likely that software publishers would prefer that it doesn't. So the Supreme Court hears cases and controversies and is going to hear specific, very, very, very narrowly whittled points of law, like the first sale doctrine in Verner V Autodesk was a very specific case. Did that license and that kind of license language affect a waiver of the first sale doctrine because the item was a license and not a copy that was being sold? So that it's difficult to say that it's never reached the Supreme Court. I can tell you that I don't know of any cases where like this specific issue in any one case has reached it, but it's more like it would have to be brought up as some sort of violation of contract or violation of a consumer protection law, and then some issue that couldn't be resolved without the Supreme Court's help, some split between circuits, or a complete misapplication of the law that then also gets misapplied at the appellate level and gets to the Supreme Court. And then it doesn't matter whether it gets misapplied by the Supreme Court because they're final and infallible. Let's see. In the U.S., there's been inconsistent lower court rulings on software licenses, but they have not been in agreement with other lower court rulings that don't apply in the U.S. I don't understand what they're trying to say there. Another Ninth Circuit Court ruling many people didn't actually conclude. What is this Ninth Circuit Court ruling? Upholds tough software licenses. That is Verner V Autodesk. That's what this is. The USA Supreme Court ruled that people are entitled to resell their copyrighted goods. Let's see what case that is. Oh, is this Kurt Sang? Yeah, this is Kurt Sang v. John Wiley and Sons. Okay, so Kurt Sang, again, this is sort of being used to bolster the argument in a sort of a disingenuous way, this author here on Linus Tech Tips. The Kurt Sang v. John Wiley and Sons was a very complicated issue with overseas copyright. So if like, let's say that I write a book, and let's say I charge $100 to college kids in the U.S. for the book, but college kids in India get the book for $15. Well, heck, wait a minute. Somebody might just have the idea to go buy a bunch of $15 books and bring them back to the U.S. and sell them for $85 instead, to the kids in the U.S. Is that legal? And at first we thought no, but then it got up to the Supreme Court, and the Supreme Court said, yes, it actually is legal for you to do that. That was what was at issue in Kurt Sang v. John Wiley and Sons, not games as a service or anything that could be sort of related to it. So if you buy a copy of Sonic the Hedgehog overseas, you should be able to resell it here. Now, what about region coding? Well, look at your license and see if you agreed to the region coding or not. If you buy a copy and it doesn't work, and it's under warranty or whatever, you might have the right to at least repair that or work around the region blocking or something like that. Do they have to, is it a violation of some kind of agreement or right or contract by region blocking something from other countries in one country, and then you bring it back to another country, it doesn't work? I don't think so. I don't think that's a violation, and certainly not fraud.
Also, I quickly want to give you the heads up. Ross Scott joined the live stream, so Witam Lego Ryzoko. I think that's the very badly Polish pronunciation because he said he was connected from Poland. So we tried to make sure his connection was fine, but he's here to ask any questions or give any of his feedback on his video.
All right, excellent. So that is our friend Chilled Insanity here in the studio?
Yes, I think he just changed his name on Discord, so hopefully soon enough he will show up as Ross.
Oh, no worries.
For now, Chilled Insanity.
I'm going to boast you to 200% there. Welcome,
also,
welcome,
Ross,
Ross.
how badly was my welcome message?
I didn't hear the last part, sorry. How bad?
I will take that as a good thing that you didn't hear it, because I was very badly butchered.
The Polish, I wouldn't. I might not know, actually. I know foods in Polish, a couple phrases.
The best part.
Okay, no worries. I just, because you mentioned you were connected from Poland, I thought you were Polish, so I asked a Polish friend how to welcome you properly.
No.
So.
Dzień dobry, I guess. It's different at night.
It's different. Okay, no worries. I was slagging off for that in the future.
I'm American. I moved to Poland. My wife is Polish. So.
Okay, no worries. Well, welcome to Europe and welcome to our conversation.
Ross, I don't know if you can access your audio settings in Discord. You're a little quiet, and I've got you turned all the way up.
I'll turn it up, but then I might start clipping. I'll just keep going a little bit more.
Okay. We're just looking for you to, about a 510 dB gain.
This is Brandon. I took care of his name for him.
Okay, Rossio, yeah. We tried to take our care best of Ross's audio. Like, beforehand, he was clipping a lot, so this was me and Tactical's best
This would be the
efforts.
setting, probably the setting in Discord itself, under the voice and video output volume.
Well, I have a DAC, so I just have to keep turning it up, and then I just worry I'll clip, but if I don't, I don't. So I think it's up on max for Discord.
Yeah. Oh, if it's already up on max on Discord, yeah, you're screwed. But that's good.
Well,
I think you're coming through
Ross
okay now.
sounds fairly perfect now compared to 5 seconds ago. Sorry for interrupting you. Please, Leonard, continue.
No worries.
Yeah, I wasn't trying to disrupt the flow here.
Let's see. I've already made it up to Kurt saying we're into that Linus Tech Tips things. How are we doing so far? What do you think? Do you have
I
any?
had one question I think that you sort of touched on. I have a couple questions, but one I think you touched on before. Am I correct in this? Like when you were talking about buying the functional client, am I correct in assuming there's no like legal expectation of a working game, just the client?
I guess in what way do you mean? Like if it makes me think of Fallout 76 because I was very disappointed by their launch. I didn't feel it was
that
a
game
working
runs
game.
though.
It does. It runs. It functions, but does it meet the expectations of the consumer? Is it what the
Oh
consumer?
no, you're way past where I'm aiming in the video. And
Okay.
man, that whole video, I'm in no way trying to. In my video, nothing in there am I arguing that there should be a certain quality, subjective quality standard. But I think whether the game runs is an objective thing. Like, but that's why I was wondering if there's...
Well, I would consider a violate, like if the game doesn't run or something and you've paid for it, yeah, you've definitely got a claim. If it's a contract, like you paid for something and didn't get what you paid for, that's a contract violation, or could be a consumer protection violation.
Well, you say you didn't get what you paid for, but it sounded like a second ago you're arguing I paid for the client. And hey, the client could run exactly as advertised, but hey,
yes.
Hey, the culling too. No, they gave refunds, but they shut that down after a week and a half. So let's say they didn't want to give refunds, and and their argument is your client works. It is short of any minimum warranty, local minimum warranty laws. Is that basically argument protected legally?
No, I think that someone who had purchased. I don't know the Calling 2's actual, I don't know the whole story behind it, but if they shut the game down after 2 weeks and didn't issue refunds, I would definitely think that's going to run afoul of somebody's consumer protection law or definitely the reasonable expectations under the contract. Now,
I guess where is that dividing line then?
Well,
here,
sorry if I can quickly take over, like especially from a European perspective. Obviously, there's literally right now coming new directive out, but even before that, like if a product, even a digital good, which is either a service like Spotify or something, or a product like a game, is failing to work within 6 months, it falls under warranty. So if a product does not work, it doesn't mean. Obviously, a general refund is like 14 days officially. Most give 30. But if your product stops working within 6 months, that's when you can ask for a full refund. So if they are not providing a refund after shutting down after 1 month, they are literally, at least in Europe, under contract violation because something has to work at least for 6 months.
And there would have to be some reason, something about why they had to shut it down. Even if the license agreement says we can shut down the service however we want for any reason whatsoever, the reason still has to be a legal reason. If the whole point of the endeavor is later found out to be, we're going to tell everybody we're making a game, we're going to make them sign a license agreement, they're all going to buy the license agreement, and then we're never going to deliver it because, the license agreement says we don't have to, that's not going to fly. That's going to be considered some kind of unjust enrichment or unconscionable terms or failure of consideration or something.
I'll even go fraud in that. I'll go fraud in that.
Maybe that's even fraud at that point. Here's what I was thinking about fraud.
On the license.
Real quick. Here's what I was talking about with fraud. Fraud is more like the Peachy printer, where I backed a 3D printer, inexpensive 3D printer on Kickstarter. Actually, a lot of people did, and then one of the principals, one of the people who created the Peachy printer or was working on it or whatever, took the money and used it as collateral for building their house, hoping that the bank then would give them a loan and no one would ever know that they had used the money because they get it back. Well, the bank asked some questions, and how did you get the money to build this house? And well, they didn't want to answer that question, so the bank didn't give them the loan, so the Peachy printer never got their money back. That was fraud. That was an intentional deception.
That's easy fraud. Okay, I guess here's what I'm getting at. It sounds like I'm hearing two different definitions. Like, okay, so you said, a perpetual license, or if I own the client, that has not been taken away from me. So everything's on the up and up. Like, let's say they keep it up for a year or two, then they shut it down. But then, I don't know whose name it was, they just said that, if they want to shut down the game, even though the client is still perfectly working after a month or two, well, wait, now we're in fraud or the customer's been wrong. Why? That seems like different logic. It's like one is saying the client, one is saying a functional game.
Let's take a more realistic example. The Division 1 was released 2015 or something, and if they leave it up for 3 years and then shut it down in anticipation of the Division 2, where are the potential violations there? It certainly could be a violation of something. We have to look deeper into it. Did they commit fraud in the sense, did they know that they were going to shut down the game in 3 years, and so they collected all your money knowing that you expected, intentionally deceiving you into believing that the game would be up for many years, and then it's not because they take it down after 3? I think that's going to be a much harder argument to reach the level of fraud, because they delivered a game. Everybody knew that it could be shut down at any time. It literally said it on the back of the box, and you had a chance to play it for 3 years. While not a perfect analogy, the one that keeps coming to my head is like a local carnival. Local carnival comes to town, you buy a ticket to go to the carnival or whatever, and then the local carnival leaves. Well, yes, you there was a piece of art there, or there was, a game or something that you enjoyed there, but then they still own it and they get the right to take it with them. And so same thing with the Division. As long as everybody is under their contract and the terms of their contract and is also not violating consumer protection laws, and to a point, even if they do, I'll explain that in a moment, they have the right to shut down the game when they feel it's run its course. And if there's been a violation, then that is an economic violation. And courts in the U.S., at least, have never compelled a game developer or somebody to keep the game online so much as they've maybe carved out an exception or something. Let me lost my train of thought here for a second. But
people are saying I sound like a robot. Is that still the case?
Yeah, you do still sound like it's not. You're not clipping. You're like.
I think it might be an issue, the ping, because obviously we tried to test your audio beforehand, and when it sounded perfect.
Western Europe.
Yeah.
Can you understand me at all, or is it really bad?
Hang on, try it now.
We can understand you, but it's...
We can understand you. It's just a little patchy.
Okay.
We can hear you.
No, he's better now.
Oh, that's better. That's better.
It's a lot better.
And
actually.
I did nothing.
That's no, we did it. I changed the server, and Discord does it pretty seamlessly.
Okay. Well, I guess two things. One, I understand the carnival analogy, but the carnival, they're telling you how long the ticket's going to be for,
True.
and it's being sold as a service. However, I think you said that part may not be that important. I guess what I'm getting at is...
Well, the Division was sold
like in the beginning,
knowing that it could be shut down at any time.
if in the beginning, if you're given a functional, if you're not delivered a functional game, it sounds like the law's on the side of the consumer. And at the end, the only requirement seems to be that you're in possession of the client. Like, at what point does that change?
Well, no, it's
If
the
I
terms.
can-
It's the terms of the license that really govern that, and each one's going to be a tiny bit different, and we're trying to speak in general terms about something that really is individually different for each game, but they have a lot of overlap.
Also, if I can quickly put my point that I want to put across, like Ross, in your video, you deliver some excellent case law, and I'm not going to rebuke that, but that is very country specific. Nothing against that. And one thing the European Union recognized in 2015 when they started to review this area is that all the countries in the EU, mainly where you focused on in some parts of the video, are not aligned together. So luckily, literally about 2 weeks ago, the EU put some new directives in place, indeed, so to prevent fraud. So one part is indeed that they have to deliver on the promise within a timely period. So they are, sadly enough, for a lot of people that are gonna hate this, they are allowed to terminate this contract at any time as a good of content. And yes, games are involved in that. So at one point they can say, we're done with this is the end. However, if in that time, let's say you sell a product and saying like, this is the division 2, it's gonna add extra content X, Y, and Z. Like, so we're gonna add endgame content and this, and they do not deliver on it, then yes, they are in breach of consumer products, and your only remedy at that point is that you can receive a discount. So let's say I pay £60 on this content, and in the beginning they promised to have like endgame content, let's say some big multiplayer feature. I know they have that, but let's just ignore that part. Like a big multiplayer feature, and at that point they did not implement it. I can legally require them to give me a partial refund. So if they did not deliver on 20% of the content, they can give me a 20% discount in the end as a refund. So whatever the price will be of 60%, like, and it's the same for services as well. Like if Netflix promised me 100 movies a year and they only provide 900 each month, then I could ask for a 10% discount. So that's something that just literally got approved on the 15th of April. It's gonna be published soon, and they have to live on 2021 because they have 2 years to implement on each country. And once again, Ross, I want to quickly reinform this. Your resources are not wrong, but they're very country specific, and we're now trying to make it in uniform area to make it one thing as EU law instead of just like France and pretend this. But Germany said you only have 6 months, but the Netherlands, they only said they have 2 months.
Okay, well, first off, don't worry about if I got something wrong. I mean, you can tell me, I'll believe that. This was my best attempt. That wasn't. But I want to get to pretend. Okay, you said the Netherlands 2 months. Pretend, for example, there wasn't that provision on the 2 months. Would it be fair to assume, or in most countries, that let's say they shut it down the next week, but you get to keep the game client? Would that be considered legal if there weren't like minimum warranty provisions in the law? I'm trying to understand the logic here.
Straight away, that's a no. Like, we're gonna try and make the maximum amount extent. Indeed, if they shut it down, like literally anyone, I forgot the game you just mentioned, but if they shut it down 2 weeks after, like currently in EU directive, if your game breaks at any time in 6 months without a reasonable like contract to go out and you accept it, then you should get a full refund. So yes, any game that at the moment breaks down, regardless of your hardware, if your hardware breaks down and they can't provide that, or if it's them breaking it, then you should get a refund. So 6 months at the moment is unacceptable to shut down any game service. And later, when this EU provision that at the latest should be implemented by 2021, it's going to be upgraded to 2 years.
Okay, I feel like you're answering a different question, but I don't want to take too much time on this. I'll just stop that. I'm still confused at what point having only the client is important versus having a functioning game. And it seems like two different standards, depending on where we're talking about in the times.
No, let's stay on this, because I think this is an important distinction. When you say having only the client, it's more of like it plays out differently in each individual case. Can you give me a sort of an example of what you're thinking of?
Yeah, well,
even a hypothetical one.
I'm assuming a lot of the EULAs are pretty similar. A lot of them, I imagine they have some provision that, well, again, in the video, that was the one, I grabbed an example, that was PlanetSide 2. And in that, it says they can shut down the game at any time for any or no reason.
Right.
But the Division's fine too, because PlanetSide 2 is a free-to-play one. Division's fine. So you buy the Division, and someone's making an argument earlier that, there's no...
Yep.
Okay, he broke up, and
now I just totally lost him.
We totally lost him. First of all, Ross, if you can still hear me, I apologize for the answer your question. In the EU, from the moment it launched,
can we try and get Ross back?
I didn't know Ross.
Do you hear me? Hello?
Yeah, now we can hear him again.
Oh, sorry, I don't know what happened.
Yeah, it broke right in the middle of your sentence, and I was trying to fix it again.
Okay, I'll just try to make it real quick. Okay, let's say you buy the Division, you pay the money, and then later they shut it down, and under the perpetual license, I think, we're saying that's okay because you still got what you pay for. You have the client, but it sounds like there's all these protections towards the beginning where there's an expectation of a working game. And it seems like different logic to me. It's like, well, when it suits the corporations, you're only entitled to the client, and when it suits like the local laws at the beginning, you're entitled to the full game.
The two things are simultaneously operating, that you have a right to your copy of the game, but that's a very limited right. So in the case of the Division with a client, there's not a whole lot to the client. The client may contain the textures and the bulk of the data, so it doesn't have to be transferred over the internet or whatever. But the client itself isn't terribly functional without the server and everything. What you own or what you received, what we would call under the law your bargained for consideration, what your thing that you contracted for in the license agreement was the right to play the game as a whole up until the time that they terminated the license. It's not advertised as that. I definitely get that this is a problem, and I'm not defending the problem as in I'm not defending that games as a service is a great model for consumer rights. I think it's a terrible model for consumer rights, but I think it stops short of being fraud. And
I'm not coming after you say like, how dare you defend? No, I'm just trying to understand.
No. But the two things, you got your value out of the game in the sense that the terms of the contract were fulfilled, and that's what we care about for legal remedies, is whether or not whether the terms of the contract were fulfilled or satisfied or not, or violated. And even then, there's a second part of contract law. You're allowed to violate a contract as long as you pay for it under the natural consequences of the contract. But that's economic. That's not fraudulent. So if I have a contract, let's say I have a contract with a local school district to provide, IT services, and in the contract it says I'll be there 5 days a week for 30 hours a week, and I just decide that I'm going to cut back to 25 hours a week. Well, I'm not guilty of anything more than violating my contract. maybe I've broken the terms of the contract, but I'm not going to be found guilty of fraud or something unless there's something more. And the something more in that scenario might be if I continue to bill for 30 hours a week and I'm only there for 25 or something, and there's some sort of intentional deception in there. Maybe just billing, it might not be the deception, but maybe billing and saying I was there for 30 hours a week. But how about this? What if you billed for 25 hours, but asked for the money for 30 hours, but it clearly said 25 hours, and you just sent a bill that said 25 hours and the price that you asked? And what if they paid that? Is that fraud? I don't know. You're getting farther away from fraud now because you've not intentionally deceived them for for your gain. You've instead, you've tricked them, but it has not been in a deceptive way. Still could be a violation.
The price
Sorry, go ahead.
before you. No, it's okay. I don't have anything important to say. I was just.
Well, if I could jump in here for a second.
Definitely.
I think one of the sort of things that I'm getting from this conversation is people are looking for bright line rules or bright line principles that can be applied to say, well, if this is true, therefore it is fraud and it's always fraud, or if this is true, therefore it's never fraud. And the problem or benefit of law, depending on your point of view, is that it can be very fact specific, and it's very difficult to draw absolute bright line rules. I've seen the chat, for example, where people are saying, well, if there's an end user license agreement and that says they can take it away at any time, and they take it down after one day, well, you're just plumb out of luck. And I'm like, well, no, that's not right. I mean, that just doesn't make any sense. That's almost certainly fraud. It's almost certainly a whole bunch of things.
Can we walk that scenario out real quick? What if somebody did that? Let's play it out in like a hypothetical, but using all the laws and all that, and not limiting it to what if this law didn't exist or whatever. If EA, for example, makes Star Wars Battlefront 3 and they charge everybody for pre-orders, and there's all this marketing hype about how awesome the game is going to be, and then they release the game today and then shut it down tomorrow. First of all, practically there would be an uproar from everybody who had paid for it, but what would be the legal consequences of it? Even if their contract said we can shut down the service or the game or whatever at any time, they're still probably in violation of many different consumer laws. But then, why would a company? What would be the only real motivation? Using like an Occam's razor style like logical deduction thing, what scenario could possibly justify them starting up a game and then shutting it down? It would either have to be some kind of massive mistake where they literally like took their own game down by computer software bug or something, or they were committing fraud. Like they literally said, okay, we're going to collect all the pre-orders and then put the game up for a day and then take it down and I'll go to the Bahamas.
Yep, basically that's exactly right.
The only way that they could do that is for it to be a fraud. You would otherwise have thousands and thousands of developers, working on the thing and all that, and then all of a sudden they would just turn it off for. No, they have shareholders to be beholden to. It would probably even be a personally liable fraud, like the principals controlling the board and all that who had approved this or who had carried it out. They would be personally liable as well because this goes so far outside of their duties to shareholders as well.
Right. So at that point, I'm quoting Hans Gruber from Die Hard, where it's like, oh, we're sitting on a beach earning 20%. I'm like, no. Something's gone massively criminally wrong at some point in this exercise. So, yeah, then it's like, okay, well, if they shut it down after one day, that's fraud. Well, then it's like, well, if after 2 years it's fraud, it's like, no. So then the next question is, where's the line in between?
Where's the line in between?
I don't know.
Okay,
that's a good question.
Just so everybody's clear, I'm not still looking for a fraud angle. I'm literally trying to understand.
Yes, but we've been looking at the word fraud. I have learned how to spell the word fraud at least 6 times over the past 24 hours.
I tweeted you. I was like, but the word fraud is in your name on Twitter.
I guess what I'm wondering here is, okay, so the perpetual license grants me ownership of the client when I buy it, but it's local consumer laws that protect, like that, what you're calling the reasonable period where the game should operate? Is that fair assessment?
Law, the copyright law, the law of first sale protects your right to own the copy and all that. When you sign this perpetual license, your license is everything, not just the copy. It's your right to have the copy, possess the copy. Let's see, I brought one of these things up here, I think, in Firefox. Let me see if I can find this. Here's an Activision one. Activision grants you a personal, limited, non-exclusive license. I'll turn this off here so you guys can see. Hang on. Activision grants you a personal, limited, non-exclusive license to use the product for your non-commercial use to the fullest extent permitted by applicable law. This license granted to use the product is non-transferable. You may not rent, lease, lend, sell, redistribute, sublicense. You may not copy except as expressly permitted by this license or applicable laws, terms, conditions, rules. Decompile, reverse engineer, disassemble, attempt to deprive source code, to derive the source code of, modify, create derivative works for any updates or part thereof to the extent allowed by applicable law or to the extent that may be permitted, etc., etc., etc. So that's not the whole license. The whole license is very, very long, but the license then governs your relationship with the product and with the provider or seller of the. I'm trying to use non-word. I would normally say goods or whatever, and I'm trying to use specific language to avoid confusion.
I think I've got enough of a grasp on it. I don't want to keep
and it's not that it doesn't suck. I'm not arguing at all that this situation doesn't suck. I want to be clear for my audience as well that this is a major problem in the way the law operates. One thing that we haven't even talked about yet is the orphaned works problem. What happens when someone walks away from a project like this, maybe even shutting it down in the process, and then doesn't want to republish their book or doesn't want to republish their music or doesn't want to republish their game? Well, guess what? They can. That's allowed. And then there's
I think I covered that in the video, actually. The delisted games part is basically
and then even worse than that, what happens when someone walks away from a project and just sort of forgets about it? And it's not that they don't want the world to have their music or their video game or their book or whatever, but rather they just sort of forgot that they owned it. This happens when people like someone dies in an estate. Things transfer from the deceased to the living, and someone now owns rights in a book or something, and they don't realize it. Maybe the lawyer just said, "Oh, you own all the rights to whatever literary works this person," and they maybe didn't realize that they owned the rights to something very valuable that people wanted republished. And maybe because there's no central registry of copyright, and there is a central registry for U.S. registered copyrighted works, but if I go and write down even the script for your video or this video are copyrightable, what if we don't register that? What if someone really wants that work for some reason? They won't even know how to get a hold of us if it's not properly registered and there isn't a valid address. Oh, sure, definitely. But that's also a problem that will affect your ownership of a game or something. If you bought something and it required an online connection and you go back to it 20 years later, you might not even be able to find the original developer to ask them, hey, can I have permission to whatever with this, to either make a derivative work or crack the code or something. To an extent, your ability to crack the code is allowed, but like you pointed out in your video, it's a lot of effort to do that. So who's going to go and try and reproduce the Division 2's server without the Division 2's server code? You're really not going to do that.
Actually, I have a quick question related to that, if you don't mind.
Yeah.
Okay. Let's say the division shuts down, but you own a copy. Somebody wants to make a code, and there's that exemption that was recently added to the DMCA, I think 1201, that says you can.
Sorry, I'm trying to fix this thing again. He'll come back in a second.
Because someone in my own forums is saying that reverse engineering is not legal. Wait, did I cut out? Or?
Yeah, you're back. Reverse engineering is legal up to a point. first, it'll be in the license agreement, so you might not be allowed to reverse engineer something that you've licensed, like we just read in this Activision section here. It literally says you may not reverse engineer.
Okay, but would something like you probably know Sony versus Bleem apply? That's where they challenged the emulator and they found that because it didn't use the code, it was legal. Bleemcast was a company. Would that apply or not?
Would that apply? Each individual scenario is going to be different in that one. In this case, Bleem PlayStation emulator, it looks like that's going to be playing like one file is all it needs. It needs like the ROM file, and it can play what was originally on the disc. What about a disc that required, what about a disc for the Division 2? What if Bleem was booting up the Division 2 20 years from now, and Ubisoft's long shut down the servers? The disc will boot up, or might. I'm not sure the disc would actually last 20 years, but let's assume the disc lasted 20 years. The disc might boot up, Bleem might be able to run it. Can Ubisoft sue you for using an emulator to try and run your client to Division 2?
No, that's not the question at all. Sorry.
Well, I'm trying to get there.
Okay, sorry.
But in your question, I think your question was limited to was it Sony v Bleem that you were limiting to, where there's like a disc and there's a set. So the problem with this is each game is different. So Ghost Recon, Wildlands, and Division 2 are kind of similar, but they're different from a single-player adventure or something. Is different from, I don't know...
I guess what I'm saying, okay, for the sake of
offline
argument, assume
Minecraft.
the EULA says no reverse engineering allowed, okay? Just for sake of argument.
Okay.
And then, okay, well, let's say the Division is like that. I don't know if it is like that, but just for theoretically here. It shuts down, and some group of people decide, you know what, we want to get this running again, so we're going to just look at the client and what the server is doing, and we're going to create our own attempt to create our own server emulator.
Okay.
Is that legal?
It's in between. It's in between. Yes, it would be fine to do so as long as you didn't need to further infringe upon the intellectual property rights of the original creator. So let's go back to Division 2. You're trying to recreate the Division 2's server. Well, if you don't have to make use of illegal use of their assets or something, fine. But what if you have to distribute, because this is a thing you're going to want to distribute to people, right? It's not just for your own personal use. You're going to want to put it up on the internet and give to other people. What if you have to distribute Ubisoft's copyrighted assets to do that? Now you're in a real legal gray area.
Let's assume it's all original code. It
is the original code, but are you talking about limiting it to the client code, that you don't have to reproduce any of their server assets?
No. Okay, sorry, I'm not explaining this well. Okay,
I think what you're trying to say is you don't have to distribute any of the copyrighted materials. You just have a server that you connect to, and you have to
you're distributing the server emulator. You're not distributing the client. People have to get the client on their own.
Right.
Buy old copies.
But what if different servers in different games are going to have different functions? Usually, it's in video games. It's a fat client, thin server, and but it would not be hard to imagine a server that contains the copyrighted content, let alone the server code itself is copyrighted. Back up though. So you're reverse engineering or creating your own server. That's fine. There should not be any legal implication there until you get to some other law, like if you have to copy some of their copyrighted code, or if you have to copy some of their copyrighted assets, like pictures or graphics or textures or videos or whatever, images.
Now, even if the EULA says no reverse engineering allowed, it's still fine. You never looked at their code for the server. You never had access to it.
If it says no reverse engineering allowed, there's two things to that. One, on its face, that means no reverse engineering allowed. If there was an exception, the only exception I could think of is maybe something carved out in consumer protection law, that maybe you're allowed to take apart your own toaster, etc. And that might include copyrighted code, that you're allowed to look inside your own copyrighted code even if they tell you not to. I don't know actually on that one. I don't know of any law that allows you to reverse engineer without permission.
Okay, well, again,
when you have expressly agreed otherwise, I mean.
Yeah, I was saying the only two that may not apply that I thought maybe could apply were one were the Sony versus Bleemcast case, because they reversed engineered the software and they weren't selling it with the BIOS file. And Sony obviously did not like that, but it was held up in court. And the other, last year, there was an exemption added to the DMCA. I think it's 1201 that says that if you're trying to restore an online game, you're exempt from that. But I'm not sure the wording on that, and that matters though. But if you're not sure,
the other question would be: is that even enforceable in a EULA? Like, can you enforce the no reverse engineering clause of an end user license agreement?
Yeah, probably. At least, again, these are things on a spectrum. If you're reverse engineering your own private copy in order to make it operable again, that's very likely allowed, and I believe there is already an exception, at least one that we looked at already in the U.S. copyright exemptions, the DMCA exemptions. If you are reverse engineering it so that you can, I don't know, sell copies or cheat in the game or something, that's much more likely to be upheld as a violation of the terms. But you should have no problem
with the game shut down.
Game is shut down. I don't see any legal issues with you reverse engineering your copy, and then if you're going to release an emulator or something again, it has to not use the creator's intellectual property. That's all. Making your copy operable is different from using their intellectual property on a server or something like that.
Okay. I get what you're saying.
Let me give you an example. So I'm looking at the Bleem page here, and there's this, I don't know, Russian or Polish or something police car, or maybe it's not. Maybe it's just a cool looking car with a stripe down the center of it. Let's say that doesn't exist in the client, and maybe even it doesn't exist in the server. Maybe it's drawn procedurally or something. Let's say that to make the server operable, you have to create the code that draws that car. You might be in violation of a copyright law or something. And if you've agreed not to reverse engineer it, you might also be in violation of the license agreement. That's a gray area. That's gonna maybe Attorney Hoeg or maybe Blackleaf knows. I don't think I know any further than that, where the line would be after you've had like a client server software shut down. How much are you allowed to recreate of the server? I think there will be a copyright issue eventually there.
Okay, I don't know if you want to keep going, or I had two more questions, and that was
sure.
it.
Yeah.
Okay. One, or I guess it was three, but I can wait.
No, keep going.
Okay, you were talking about how earlier, under the license, the game, perpetual license, the game is, you're free to repair it and try to restore it. Is there any precedent at all showing that, if they're leaving the DRM on there and just encrypting everything, to the point where, like, again, almost no reasonable person could ever be expected to crack that and restore it? Is there any precedent showing that is kind of a violation of anything, I guess? Or
not a violation, but you're not in violation to crack that code, to crack that encryption.
Yeah, but it kind of shows the intent that they do not want you repairing this. Like with maybe not in the United States, but
it shows
I think
that they
shows
don't.
The intent.
It can show a kind of intent. I don't think it rises to the level of criminal intent for fraud, if that's what you're talking about.
No, this is again. Look, I could be completely wrong on the front part. I'm just trying to see. You know what? You got me interested in your title because you were saying games as a service is not fraud, but could be a violation of consumer protection laws.
Yeah,
that's what I'm trying to figure out. That second part.
Oh yeah. Which consumer protection laws and all that are mostly what we're talking about in consumer protection laws are like unfair competition, deceptive business practices. Let me see. I had brought up something here earlier. Here we go. Variety of laws. Federal laws and state laws in the U.S. regulate consumer affairs, Federal Food and Drug Administration, Cosmetic Act, Fair Debt Collection Practices Act, etc. These are all consumer protection laws. State laws are usually part of the Uniform Deceptive Trade Practices Act, which is, the act is not the law, but it was a uniform example of a law that then gets implemented by the states individually. So their various implementations of the Deceptive Trade Practices Act will be different, but usually only slightly different. Usually we'll have the same numbers and same sections and everything, and then they'll just tailor little bits here and there. So it's when you say, does it violate consumer protection laws, and I say it could, I'm very proud of that answer. Because that's really the best that we can give you right now.
It sounds like it'd be real obvious if it did.
It sounds, generally it's really obvious. Also, there are bloodthirsty lawyers out there, way more bloodthirsty than me, who, if Fallout 76, for example, was, this is my example, if it was a massive example of fraud, you can bet there would be lawyers out there much more powerful and much more who have much more resources, much more litigious than me, who would be representing people against Bethesda like mad. Now, that doesn't mean that we couldn't all collectively miss it, and one of us has to be the first one to go, hey, this is fraud, or this is a violation of consumer protection, or this is a violation of something. There could be that one. There weren't BitTorrent cases 10 years ago, at least not en masse, and then lawyers figured that out, and now there are thousands of BitTorrent cases keeping my practice and other practices afloat.
You mentioned Uber earlier. That's actually exactly what it reminded me of when I was reading about it.
Oh, the distinction between contractors and employees?
The contractor versus employee, that sort of thing.
Yeah, that's a really important one, too. If you get that one wrong, you can end up on the wrong side of a lawsuit or charge or something like that. Let's see if there's anything else here. The Uniform Act, Deceptive Trade Practices Act, contains a private remedy, which means a private cause of action, civil remedy. You sue privately in court, with attorney's fees for prevailing parties, where the losing party willfully engaged in the trade practice, knowing it to be deceptive. So if you felt like, and I know that definition really doesn't get us that much closer to is software as a service or games as a service a deceptive trade practice, well, you have to make up I don't mean make up as in from nothing. I mean, you have to put together a whole series of events that makes up the deceptive practice and then the damage from it. And they have to connect, and they have to connect in a legally cognizable way. There has to be not just what we call but-for or factual cause, but also legal proximate cause, which means that, if I cause traffic to shut down because I had a car collision because of my negligent driving, and you're late to work 15 cars back, you don't have a claim against me. That's proximate cause. Yes, you're late to work but for my getting into a negligent motor vehicle collision, but the law does not recognize that because you got jammed up on the highway, not even part of the collision, but just because you got held up on the highway means that you have a claim against the initial driver. I guess there would be at some point where an egregious enough violation, maybe, but we had there was a very famous case involving a woman named Palsgraf, which is I say that word and every lawyer on stream will know exactly what I'm about to talk about. And she was at the train station, and some idiot carrying a box of fireworks onto the train and having trouble with it or something, and the fireworks fall and the fireworks go off, and in the pandemonium, this big giant metal scale falls on Ms. Palsgraf and injures her. Can you sue the guy with the fireworks? Because in the giant pandemonium that he caused, she got knocked over, or a scale fell on her and injured her. And I forget whether this injury was serious, but it's a big giant scale. These are massive things for weighing cargo for being transported by the train. So this is not a minor injury, but she still can't sue the guy with the thing because the scale fell on her. He didn't cause the scale to fall on her. He caused the pandemonium with the fireworks, and then somebody reacting to the pandemonium knocked over the scale, and then she. So yeah, it's a but-for kind of thing, but we also don't recognize the legal proximity of it. I may have gone too far with that one.
It's okay. It's your podcast. Your show.
I tend to get a little.
It's your podcast.
Ranty.
I love it.
You just had to say Paul's graph, so everyone went, "Ooh, Paul's graph."
Yes, we need to do a reenactment of the Paul's graph scenario.
You just want to bring in Eevi and talk about.
I heard a suggestion about 3 days ago. I think it was in our patrons channel. Somebody said we should do VR chat cases. That's a really good idea.
Yeah, that would be fun. You
want to bring in Youngstown Steel or Erie or International Shoe for no particular reason while we're at.
Oh, come on. We've already talked about International Shoe and Bell Atlantic v. Twombly like 1,000,000 times on this channel. These are our jurisdiction cases. They're very foundational jurisdiction cases.
Couple quick questions still,
yes.
if you don't mind. This is very helpful. If you saw the minimum effort option I put down there, would you see any problem with the developer doing that voluntarily? Like where they release the packet documentation, just open up disable the encryption, so they're not giving away source code, they're not giving away the intellectual property, as I understand it.
A developer could do that, and that would be an awesome thing to have the community support, and maybe even some developers start doing. You could even use trademark law. There's something called certification marks, which are like the most famous one that everybody knows is champagne. You can't call it champagne unless it's from the Champagne region of France, and there might even be some more regulations there. And whoever owns the certification mark, usually it's like a group, like like we represent the people who make this type of good, and we want to make sure that they're all protected collectively. Usually it's that kind of collective protection. You could do that here and have games certified as end-of-life friendly or something like that, and the trademark could be something like end-of-life friendly or something more creative. And then game developers could put that mark on their properly end-of-life prepared games, and with your approval, and maybe even the paying of a small license fee, which is how this happens. How we end up getting those kinds of things all over boxes. That's a little different.
I'm not talking about a working game or a working server at all.
Okay.
I'm talking about making this from a near impossible task to just a ton of work task for the community.
That's what I was meaning, where they've taken some kind of step and some organization has certified it. I was just giving that example because that's a way to use the trademark law we were talking about before. That they would pledge, make a legally enforceable promise, either in the license agreement or by being part of a certification mark, like I was saying, that they would prepare the game for its end of life in such a way that the community can take over. That would be
even that's more
a soft solution, a very, very, very soft solution, and not certainly something.
Say you had a game, again, the division shuts down, and hey, some of the developers say, well, hey, we want to throw a bone to the fans, but then legal's like, well, we don't want to open ourselves up to any liability. What would be the argument? Or we don't want to have to spend time on this. What would be the argument?
Oh no, it's exactly what I was just saying. You would want them to prepare something where the software and stuff that runs the game can be sent away, and then to prevent them from having any liability, they would it'd be another part of either a new license agreement or part of the existing license agreement that, upon termination of the agreement, they make it available to the community for 1 week or something, and then shut down their servers and pull their copies that they are making available, and then it's all yours, as is, no warranty kind of thing. I don't think that there'd be any problem with that from a legal perspective. It might be a problem from the business perspective. A lot of times these companies don't want to give that away because they're going to want to make this game again in 10 years or 20 years or whatever, when they've run out of creative ideas, and instead just want to go and rest on their laurels. I'm being a little bit insulting here, but rest on their laurels and make a new game out of their old game. And so they don't want you to have Star Wars Knights of the Old Republic forever, because that's going to make it harder for them to make a new Star Wars Knights of the Old Republic. Except that logic is flawed, and maybe keeping people happy with the old one is going to still want people are still going to want the new one. But I respect that the company has the right to make that decision for themselves, even if I disagree with that decision, even if it's a mistake in my opinion. They still have the right to use their judgment in their business.
Yeah, but there's no legal risk for them if they decided to do that.
There's no legal risk if they did it. Yeah, I mean, there's probably a way that they could get themselves in legal trouble, but I don't see it as being an easy thing to do if they just released something that the community could use and then washed their hands of it.
Yeah.
I don't even know that they need to do anything with a tremendously complicated legal document or anything. I just think disclaiming any warranty and explaining that this is the end of life and they're walking away from the project, but here's the resources for it. I don't see any legal issue there whatsoever.
Okay. Another quick question. Is there any substantive difference between everything that was brought up here versus, let's say in the future you have streaming only games and you can buy them, but it's reliant on the service? Would there be any? I'm assuming there'd be nothing preventing that, right? Yeah,
this is the problem, and this is where the world is going. Already I know. I mean, me personally, I'm not talking about anybody else but me, but I'm assuming a number of you as well. I don't buy physical copies of my DVDs anymore or Blu-rays or whatever. I just stream it online and maintain my subscription to Netflix or whatever. So yes. Have you identified that the fundamental paradigm of ownership is being changed? That the fundamental rights of ownership and all that, or scenarios of ownership are being changed? Yes, but we're also more or less slowly volunteering to do that. If they put video games on the shelves at Best Buy and none of us bought them, well, whose fault is it that none of us bought them? We didn't go to Best Buy and buy them off the shelves. We bought them off of Steam. And so Best Buy stopped carrying video games on it. They do now. They do carry some still. But for a time there, they really stopped carrying video games on their shelves because nobody wanted to buy a boxed copy. And heck, even today, when you buy a boxed copy, half the time you don't even get a real copy. I don't even think I own a CD or DVD or Blu-ray player anymore.
You have at least one in your
realization.
Your PS4.
Right. So there you go.
I only have one final question, so maybe if you want to cover other stuff first, or.
Sure. It doesn't matter. I'm still on minute 27 on your thing.
Okay.
But I can cover some of these real quick.
This will maybe tricky.
What's that?
If you were looking to stop this practice of, again, the destruction of the game, do you see any legal angle whatsoever in the United States? In your opinion, I'm not.
No. So I see two major scenarios where there is a sort of offline, or the game does not require the service component in order for the game to work. You have every right to continue playing the game, and even to reverse engineer or circumvent the digital rights management in order to continue playing the game. But the developers are also allowed to create the game with an online component or whatever, including making the game just designed in such a way that that you'll be required to maintain a subscription or maintain an online presence or something, and then they get to choose when they shut that down, as long as that's within the terms of their agreement. And even if it's not within the terms of their agreement, they still get the decision, and you just have to decide whether you make a legal claim or not. So no, I don't see a solution to it, because the other half of this that we haven't talked a lot about is that the developers have rights too. They have their bundle of copyrights, the Section 106 copyrights, 17 USC 106, and those rights are pretty sacred too. The whole purpose of copyright is to promote the creation of new works, new scientific, artistic, creative works, and to do so,
not old.
and to do so, it grants the author the exclusive right to their works for a limited time, but that limited time is very long. It's more than a lifetime. So a work that's being created today, I will not see it as sheet to the public domain in my lifetime, unless the producer specifically says I'm releasing my copyright and basically grants an unlimited license to everybody.
Well, let me ask a question myself in terms of what can be legally done, because I assume that Congress, in regulation of its Interstate Commerce Authority, could pass some kind of laws that would require games or other medias to be operatable in certain conditions for certain periods of time, or digital copies could be resold under certain market conditions. So I think that would be okay. Do you think there's an avenue for an individual state, such as California, to pass a regulation or law that says something along the lines of, if you want to sell your Battlefield 4 game in our state that has an online component, that online component must be operatable for at least 1 year after the first day of sale? Would that be legal? Would that trigger probably...
yeah.
Or would that trigger like some issues dealing with...
Dormant Commerce Clause?
Dormant Clause was what I'm looking for. Yeah, thanks.
So what Blackleaf is talking about is who has the right in the U.S., the federal government or the state government or both, to regulate video games and when they could be terminated or shut off. Well, I think it's still a contract right, so I think states probably have the right to do so within their borders. But then again, we have what's called a Dormant Commerce Clause. This is somewhat complicated. The right of the federal government to regulate interstate commerce is so broad that it even extends to preventing the states from regulating interstate commerce. So if the state regulates commerce in a way that touches interstate commerce, that is it voidable? I don't think it's automatically void, but I think it's voidable. I don't remember how this works. But the point is that the states do have a limit on the amount of regulation they can visit upon interstate commerce. And it's basically none. They basically can't regulate interstate commerce. So if a state makes a very cleverly worded law that says that any games sold within the state's borders, so it has to be limited in some way so it's not interstate commerce, that are sold within the state's borders or whatever, that include an online component, must maintain an online presence for a certain period of time. Sounds like an interesting idea, is my lawyer answer. It certainly could. I'm not up on my Interstate Commerce Clause and Dormant Commerce Clause jurisprudence on that one. Take a quick look here and see if Wikipedia can bail me out. Also known as the Negative Commerce Clause.
Yes, Leonard is now doing specifically what no one should do, which is going to Wikipedia for legal.
Wikipedia jurisprudence is a thing.
No, I love to start with Wikipedia.
It, but he knows how to find it.
Let's see. Prohibits state or municipal laws whose object is local economic protectionism. So I don't know. I don't really feel like this is local economic protectionism so much as consumer protectionism. I think we would need to do a much deeper dive on when the Dormant Commerce Clause butts up against state consumer protection regulations, because the state has all the rights to regulate consumer protection, health, safety, welfare, and consumer protection. Business laws, contract laws are all states' rights. So I would think yes. I would think yes, you can regulate this behavior at the state level. The court asks whether it discriminates on its face against interstate commerce. And discrimination simply means different treatment of in-state or out-of-state economic interests.
Yeah, that wouldn't apply. They're not discriminating because it's another state's thing. They're not saying that.
Yeah, they're just saying that if you want to sell,
something.
if you want to sell cars in California, they have to meet California emission standards. That's not a Dormant Commerce Clause problem, and California has been allowed to have different emission standards. They're more strict.
Right.
They're not less strict. They're not allowed to be less strict than the federal standards, but they are allowed to be more strict than the federal standards. And so a lot of car companies make their cars to the California standards and then sell that throughout the United States because that's just easier. And that's what we're kind of getting at here, is if we get one state on board, especially California, on board with some kind of addressing of the games as a service problem, that would probably start a domino effect of either other states implementing the resolution or developers and distributors and games producers to just do that because it's easier to meet the common denominator of California than try to make games just for California and something different for the rest of the 49 states plus the rest of the world, which they already have to do for the rest of the world. So, the game might be released differently in the US or advertised differently in Europe or might have censorship in China, which is one thing that seems to happen a lot. All right, so let's keep going because I don't want to keep you here all day, nor do I want to be here all day.
Sorry for hijacking.
No, you are. It's awesome that you came. Thanks very much. I was thinking of reaching out to you. I just hadn't wanted to do it quite yet because I figured I'd want to get through this stream first, and then we could answer any further follow-up questions or something. But it worked out, so thank you very much. Appreciate that. Let's see. You talk about the right to repair, minute 29. Planned obsolescence and everything like that is definitely a problem, and I think it needs to be regulated as well, but it doesn't really trigger software. It's mostly a hardware thing. So maybe if we're talking about the Nintendo Switch console or something, yeah, I'm 100% on board with there needs to be a right to repair, and there shouldn't be any restrictions, let alone even active efforts made on the path on behalf of I guess potential plaintiffs against people who are repairing laptops or cell phones or Nintendo Switches, like Louis Rossmann or Bosnian Bill. Let's see. Right to repair physical goods. And then you're going to write the law fresh in minute 32. And I happen to agree. Developers need to be more clear about the ways that the games and services can be terminated and when you might be able to expect that to happen. My dictation software is only half working for some reason. I do think that subscription games qualify as games as a service. The service of providing updated content, etc., to keep subscribers paying is the service. I forget what you were talking about, minute 35, but my response is that developers have expectations too. They might want to produce a game and intend it to last forever, but then realize it's not as popular or as successful as it needed to be supported forever. They're allowed to make money and try to squeeze profit out of their product, as well as we are allowed to complain about, games being expensive or not getting what we wanted or something like that.
In case there's any confusion, I was never arguing developers should support the game forever.
It's not that you were arguing it, but it's kind of a natural conclusion to get to.
No, it's really not. You do that minimum service option. What do they have to support? They gave a bone. If fans
have
wanna
you
keep the
tried?
game
Have you
going,
developed software before? Like everything goes wrong under the sun. Projects take 6 times longer and run 10 times over budget and all that. So it sounds very simple for them to provide an end-of-life planning service and everything, but I think it's also a burden for us to ask them to do that. I think Richard
talked to some
Hoeg...
developers about that. That's why.
In some cases, it will be no problem. In other cases, it will be a massive undertaking, and that's not for you. I don't mean this in an arrogant way, but that's not for you to decide. That's for the individual developer to decide how they want to make their art / creation / good or service for selling in business.
Well, I'll agree and disagree that that's the natural conclusion, saying that they should support it forever.
Well, I don't necessarily mean forever, but that the law can dictate that it has to be supported for longer, or that there's a claim if it's not supported for longer or something.
I get that part, but I don't.
And then
if I'm a developer that says it's heaven and earth to take away, to remove the packet encryption and release the packet documentation on that.
If that's all that it was, yeah, but some games are going to be more complicated than that, like The Division 2, for example. The world is managed by the server, and the client really just does its job drawing everything, and I guess there's some anti-cheat in there too. And I'm sure there's a lot more than that. I'm oversimplifying, but what I'm saying is you're shifting the burden to the developer to plan for this, when maybe what about the lubrication aspect of this? Weird word to use, I know, but I'm talking about the economic lubrication of it, as in the developer does not have to spend resources or plan for adhering to some end-of-life regulation on their game. As long as they've made the license agreement clear enough, they can just announce the shutdown or whatever, shut down their game, and then move on to doing whatever they're going to do next. Otherwise, we've raised the costs of development and support by having to have them make a plan in order to be compliant with the law and not face further legal action.
I don't want to derail your thing anymore. I'll just...
let's see.
I'm really happy to have you here, Ross. Like, just to be very
we are.
Look.
Hey, maybe he wants
that minimum service, that minimum effort option. I'm not exaggerating at all when I say I think that would be easily under 1% of the total budget, and a poor scenario, a few days' time to do that. So yes, you can argue that really sets things back, but because we're not talking about a working game at the end of that. We're talking about making this not trying to crack Nazi code with Enigma here.
Let's see. You made an example of the flock. I don't actually know about the flock's example, but I argue that the flock shouldn't need an exception or something. That if the parties can see the terms and agree to the terms of the contract or license up front, yes, it's possible someone could make an improper contract or forget a term or something like that, and then they go and shut down the game on the millionth death or whatever, and people are like, I didn't know that was going to happen. But assuming that part is not in there, then why would we want to tell them you can't make a game like that unless you also do something to preserve it so that people can play it for posterity or history or in a museum or something like that?
Well, that comes down to the preservation part I talked about, where for me it's honestly an innate value.
Let me make a stretchy analogy.
I realize
here.
You're going to have different views on that.
Let me make a stretched analogy here, but I like this analogy. A couple years ago, I saw some Buddhist monks. They made a sand painting. They take these individual grains of colored sand, and they very carefully place them without any glue or anything holding them in place. They make this giant painting out of millions of grains of sand, and they've taken, say, like 3 of them like a week to do the thing. They then like present it to the community as a finished thing, and then brush the sand away and go home and start another one or whatever. There's the art is valuable in part because it is temporary and not permanent. What where is the room for that in allowing developers to create their games as they see fit? Not necessarily that every game has to disappear on finish or whatever, but that what if that's what they want to do? Isn't it their right to make their art as they see fit?
Did they say, oh, the sand painting could last, we could shut it down at any time for any reason or no reason?
How about they say shut down, we're going to erase the sand painting 15 minutes after we finished with it. And you don't know when they're going to finish. They might finish after they put on some very simple patterns, and you expected it to be this Mona Lisa work of art or this giant, lots and lots of detail and intricacy. There's a disagreement there, but that's not a violation of the contract, the terms of the contract.
Okay, I'll try to keep this brief. My main counter argument to that is without a doubt their artistic intent. Right? Show me, the Flock was an example where, no, we don't care how this game does. We are going to kill it because that is our vision. Show me a major company doing that, saying that, oh, let's say it becomes a blockbuster. It has Fortnite numbers. No, you know what? We're happy that we made a lot of money off of it, but it's not our vision.
Vince Gilligan.
Keep it going, and we're going to kill it. Show how many
Breaking Bad,
developers
Vince
do
Gilligan.
That?
Stuck true to the form, stuck true to the art. He eliminated or terminated the Breaking Bad TV series after the 6th season, even though he had millions of dollars on the table. As if he could just write more of a story, keep the thing going for another season, they would offer him millions of dollars or whatever. And he said, no, we want the art to be pure. And I think that's part of the thing here is we need the developers to have that ability. Sure, I'm not at all arguing that every developer puts their heart into it and is making purely artistic choices. A lot of the times they're making business choices, and we don't actually like it that the business choices are hurting our games and hurting the art of our games. But we have to leave the room for it to happen, no?
I completely respect if that's the artist's intent, fine. I even said that the Flock should have an exemption as performance art because that's their vision. I think I would argue 98, 99% or more of these games that are getting killed, they're not getting killed because that was the artistic vision. They're getting killed because it's just not bringing in the money the way they hoped. And the path of least resistance is to just do nothing and the game dies. And somebody's saying in the chat we can still watch Breaking Bad.
Yeah, but you don't get a 7th season, is what I'm saying. Is that was you can't
but
compel.
You're arguing a point I never made in the video.
You can't no. The point I'm making is that you can't compel an artist to create more art, and at some point, having to maintain their game in some sort of playable format after their intended end of life, however they've arrived at that intention. I think you're at the boundary of telling artists how to create their art or having to alter their art at the beginning or middle or even at the end of creation to make sure that it accommodates that either desire or law if we're going to put it into a law.
I think you're strawmanning me on the maintenance part, but I'll just say that it's more we're trying to prevent the artist from setting fire to it that we paved to see the art and could easily be preserved, but he's choosing to set fire. It's debatable if he's even really choosing to set fire to it.
But you got to see the art. You got to play the art. You got to play the game, and now we're wondering when it's going to be. We're arguing over whether it can be shut down at the end of its life, or whether they have to provide for some sort of end of life planning. And I agree that it would be awesome for game developers to provide for end-of-life planning. But the other practical side of that is that they have no economic incentive to do so. There has not been one game that I can think of where people have not bought it because they were afraid that it would get shut down, at some point. The latest one that I remarked on was Battlefront 2, where at least there was enough community backlash that sales were affected and the company decided, well, maybe we shouldn't be this gung-ho about microtransactions and slow progression in our game that can only be bought with microtransactions.
Okay.
Only be accelerated.
Can I try an analogy? I know that turning digital goods into an analogy almost never works, but I do want to try one here. So, what if somebody creates a piece of art that needs to be maintained and sells that piece of art with the premise that they're going to maintain it, right? And then, so another person owns the piece of art. It belongs to them, but it's being maintained by the artist.
Yeah.
At what point is the artist allowed to pull out of that agreement and say, I'm not maintaining this anymore? So like a physical piece of art.
That would be a big deal. That if that item was, so if the agreement said, I transfer you this art and in consideration for your payment or whatever, I will maintain this piece of art, period. Doesn't say forever, doesn't say for one day. What's going to be the term? Well, in contract, we usually use we usually use the law to fill in the provision with something reasonable. What do people normally sell art with? Do they sell art with a 2 years worth of cleaning and maintenance, 20 years worth of cleaning and maintenance? Certainly you couldn't tell the guy that he has to maintain the piece of art for 100 years. He's probably not even going to live to be 100 years. Does that mean that when he dies, his estate has to come back and clean the piece of art? No. So there's a line here someplace. And yeah, but there's no automatic answer. There isn't going to be the law says that when somebody agrees to maintain a piece of artwork and then they don't do it, well, they were supposed to do it for a year. It doesn't read like that. A judge has to look into it, has to look at the evidence presented by the parties. The advocate for the owner of the painting is going to be bringing all their other evidence that the time period should be longer. The person providing the maintenance is going to bring all their evidence that they think the time period should be shorter. There isn't a clear answer on that, in other words, is what I'm saying. So if they just stop short there, yeah, big problem. And that's why you want the license agreement to be clear as possible.
I'll just add, I think it comes down to a value-based thing, because a lot of these arguments, you can say that like, let's take something, obviously it's more serious, but let's take something like child labor or minimum hour work week. That's a variable thing, but at some point, and it's the sort of thing where, well, the business rights, they're going to want a certain standard, but the public at large is going to want a different one, even if that's not reflected in their consumer behavior. Let's say at the in the old days of the local factory, well, it's kids getting the coal, and the public's still going to buy the coal to heat their house in the winter, but they don't like the fact that the kids are working there. But again, that's a more extreme example. Yeah. But to understand the general logic I'm getting at, if you don't hold preservation of art in general as a value, obviously there's a million exceptions and conditions, then I think you come to very different conclusions.
And I think the problem here is that even if you asked 100 judges and provided them the same case, you'd get different answers from the judges and different rulings.
Very possible.
It is value based. It absolutely is value based, and there's not one right answer. That's the bottom line in this entire live stream. Is there just isn't one right answer.
Yeah. And I see that Attorney Hoeg is still here. Wow, thank you for hanging around. And thank you, Ross, of course, and everyone else for hanging around, too. I'm not quite done yet. I still have a conclusion that I want to read, but I figure I'm probably done with the minute-by-minute play-by-play that I was doing. One note that I had here about patches. So you have updates and patches that might change or alter the game. Yeah, that all also has to be provided for in the license agreement, or that might be a violation of your rights. They've taken something away from you. I like to use my World of Tanks account as an example. If I buy a premium tank and then they later on change that premium tank in such a way that it's no longer the same thing that I paid for, I probably have some kind of claim, and I can probably email Wargaming and say, hey, give me some portion of my gold back for buying that thing that you to change. And I believe they've even offered that for things that they've had to change and alter. And I'm not even sure that they're even bound too much by the law. Really, I mean, who's going to sue Wargaming in the United States for a single premium tank or something? It would have to be something more egregious, most likely. But let's see what else we've got here. So let me just go over my conclusion here, and then we'll probably take it out unless there's more questions. There's certainly a lot to go over. It's a very complicated topic. It's actually the kind of the intersection of many different topics, as we're finding out
Oh, this
here.
is very helpful for me.
Oh yeah, like copyright, contract law, fraud, all this stuff comes
Consumer
together in this
protection
topic,
laws, which aren't even just one law. It's not like there's one law that says everything is consumer protected.
There's not like a consumer protection attorney. There's like many different facets of that you have to talk about in accounting and copyright within consumer protection and all of that,
So modern games with online or service-like components should include a transparent end-of-life plan disclosed to the consumer at the time of purchase so that no one is surprised when those services end. Games are goods, but games are also services. A court will look up the various rights involved. When we talk about a game as a good, it's usually that individual copy. In the US, this is the right of first sale. In the EU, this is the exhaustion of the distribution right. It means you own your copy and have the right to pass it on. Now, this is easy to get around for digital and intangible copies. You can write a contract or license around it, and then you can't even transfer your digital copy. A physical copy, though, is yours and can be transferred, except under that Autodesk situation where they had a physical copy, but it was still under a license. So it's still possible to do that. Just keep your eye out for that. The online or service-like component might disable the software or game at a later date. This part is part of a range or a spectrum. This could be a genuine service like maintaining an online world with everyone's connection to it, or it could be sinister and intentional, even fraudulent, by requiring an online connection just for a paid-for single-player game. Developers do have the right to keep their code. By the way, I'm not saying that's automatically fraudulent. I'm just saying that it could rise to that level if someone intentionally made a game and then took it offline or something and kept the money, even though there was no reason to do that. Developers do have the right to keep their code. The Copyright Act was made to incentivize the creation of new creative and scientific works by protecting them for a long period of time, giving exclusive rights to the creator or owner. Although the software game licensee buys a copy of the game in their mind, what actually happens is in 2019, you license your use and ownership of the copy under an agreement. We often complain about these agreements being so long that no one reads them. And once in a while, we find a particularly egregious term that gets the community up in arms. Well, what is fraud? Fraud is a deceitful or willful practice or device used with intent to deprive another of his property or right. It is an intentional tort or crime and requires a criminal mind or mens rea to be proven at trial along with the facts of the crime. And courts in the U.S. require fraud to be pled with particularity, meaning you'll have to find the specific, particular sequence of events with evidence that make up your accusation that you were intentionally deceived to deprive you of your property or rights. So that means it needs to be in your pleading. You need to know it up front. You have to. Fraud is so often pled improperly that the courts have now required that you plead fraud up front and not just say they committed fraud and then later on try to prove it. You need to say how it was done up front. In my opinion, you'll have trouble convincing a judge or jury that the license you agreed to and the fee you paid were somehow part of a scheme whose purpose, in major part, was to defraud you and others of their money. The argument can be made that you received less than you thought you would, or that they under-delivered on their promises, but cases of actual fraud are very, very few. To me, fraud would be when I backed the Peachy printer. We went over that. They used the money to build a house and then couldn't get the money back out of the house because the bank asked basic questions and wouldn't grant a loan. That's fraud. But a company shutting down a server-based game that they had control of and you agreed to a license, it's breach of contract at worst, and you're likely bound by an arbitration clause and prohibited from filing a class action because you agreed. See the South Park Human Centipede episode. There are limits, but these companies hire clever lawyers who do their best to make the argument in their favor on as many of these points as possible. And courts have ruled that breach of contract is economic. You're allowed to breach the contract and suffer the contract damages. With very few exceptions, it's not fraud or an additional legal violation of some kind just to breach a contract. It's just an economic breach. What can you do about it? Well, as much as we don't like to say it, continue voting with your wallet, pay attention to these issues, talk, these live streams, these videos, read your EULAs, or at least be okay understanding that you're going to get what you get when you don't read your EULAs, and pursue individual cases of violations as you see fit. Is it unfair? Maybe. You have the right to use these same tools and set up these same relationships with your clients. And since it's normal to do these things, you won't be standing out as using any egregious legal methods, as long as you stop short of fraud.
I just want to say one sentence. I have never known an anti-consumer practice to be rejected in the games industry if it was also coupled with a good game. Like, I've seen it rejected for bad ones. I've never seen it rejected for good ones.
Battlefront 2. Wasn't there a big backlash about Star Wars Battlefront 2 and the microtransactions and...
Did people say that was a great game?
I thought it was a good
I
game.
will stop short of issuing an opinion. I didn't actually play it. We know how that goes. Speaking about things
when I think of great ones, I'm thinking ones that just... They win awards, just set records for sales. I mean... Like a lot of people, I haven't played it. A lot of people think The Last of Us is great. A lot of people love the Grand Theft Auto series. Or, I've seen this happen. I think this may or may not have been the first. Assassin's Creed 2 on PC, I think, might have been the first online-only DRM for a single-player game. But a lot of people love that game.
Yeah, with De Novo.
And Diablo 3 set records.
But here's the thing, though.
One of the first kind of server-based. Can also be a completely single-player kind of game as a service games.
If you're playing Assassin's Creed 2 and the game's gotten old and they've decided to shut off the DRM server, yes, that sucks, but that's also exactly that scenario where the U.S. Copyright Office said that you can circumvent that DRM without any fear of a lawsuit.
I know, but the whole point is we're heading into the future where that's not going to matter. If there's an exclusive games on Stadia, you're not circumventing anything once they shut that down. But that was the reasoning behind my vote with your wallet
Stadia, because they're streaming from there. Yeah, and that's another reason why the paradigm shift is going to continue to happen. You're going to have a more robust internet connection, and so your software is going to be streamed to you instead. And yeah, they're going to have even more power unless consumers fight back, including legislative action. I'm calling for moderation with the legislative action because I too am also a aspiring video game developer. We want to make Lawyer Simulator, and I don't really want to. I haven't even thought, what's going to happen when we shut Lawyer Simulator down. That hasn't even occurred in my mind yet. We don't even have the beginnings of Lawyer Simulator. I haven't even thought about, what would happen if we shut it down. Now, it's meant to be a single player game, so I don't think we're going to have an issue with shutting it down. But I'm concerned about adding barriers to entry and having to plan for end of life. It's not necessarily the worst barrier. I'm not disagreeing that it is within the realm of possibility for developers to not just budget but plan for the end of life of their product in a reasonable way that protects consumers. I stop short of thinking that we need a law to do that. And I don't see it happening by itself, but
I'm more of I look more at it from an outcome perspective. Like if it's almost not happening at all, then you're right. I completely agree. No law needed, but
yeah. So how about taking it out? Is that our show, everybody? Is that the end of our 2 hour and 23-minute live stream?
Yep. Well,
Brandon,
thanks. This is tremendously helpful for getting information.
Brandon or Blackleaf, do you have anything else to add? Ross, do you have anything else to add?
No, just thanks. This was Educational. So.
All right, then I'm going to take this out. Thank you very much for joining me. I am Leonard French, your favorite copyright attorney, and with me has been Ross Scott. Is that right, your name?
Yeah.
From Accursed Farms. And we've been talking about the games as a service is fraud topic. So thank you for joining us. There were over 600 concurrent viewers at any time, and we've had about 4,000 playbacks. That's nice. Thank you very much for joining me. This is a community-supported channel. Thank you very much for supporting us on sponsus.org/u/lawfulmasses and on patreon.com/ljfrench. Thank you to our April 2019 supporters. Yes, I know it's May, but Patreon is still processing your sponsorships. So the same thing will happen next month. The May supporters will get one day into June. So thank you to the April 2019 supporters at the $50 level: John Steele, Gavin Barnard, Eevi, Andy, Kyle Mudrak, Verement, Tayne, Michael Pearce, Terry Crisp, Richard Fournier, Spirit Bear, Jan Negrey, Daniel Perez, Aspernari, Snorre Wisotzky, Sean McNamara, and Aetaric. Thank you very much for your support. And thank you to all the $5 plus supporters who are scrolling on the LED panel behind me and are in the description of the video below. Love you all. I am receiving a phone call, which I am going to decline. If my phone will let me. There we go.
Hello, receiving a phone call. I'm Dad.
All right. So it's been a great show today. I wasn't planning on taking a day out of my life to go over this today, but we managed to make it work. So I hope you enjoyed. I know it wasn't as well thought out as, say, Richard Hoeg's virtual legality. I believe it's a virtual legality podcast. So go check out Attorney Richard Hoeg's podcast as well if you'd like another take. Spoiler alert: we say many of the same things, which is actually kind of how it should happen. If we're both doing our job, we should have similar opinions. But he has just a nice way of speaking and thinking that it comes across as well. I've got a lot of liveness and ums and ahs, and but others have clarity of thought. We work on it.
I disagree with a lot of his non-legal parts, and but I'll talk to him later.
Sure, definitely. All right, everybody, have a good one. Love you all. I'm Leonard French. Have a good night, and I'll see you tomorrow.